But these are lordships. Well, there are two appeals, one by the Guwahati High Court and the other by the private person whom I am representing with my friend Mr. Somo. Now,
my senior will start off. He'll take some time, my lord, in the matter today. My lord, I have a personal difficulty, my lord, that rule committee meeting is fixed at 11 today, my lord. So if I can, because I can start rejoin back, my lord, on the next day, I'll complete my arguments. My lord. I'll take hardly 50 minutes.
If you can finish it off today, we'll finish it off today.
My senior will take some time. This matter will
That's
take
what.
will take some time.
Midway, it'll be difficult. to
Difficult,
resolve.
difficult really. That's why I just wanted. But that deadline is 3rd, my lord. So
No, I understand, but rule committee meeting of during the court working hours is
I
difficult.
can't help it. None of the others have joined in.
You have to tell them that the
I
court
have to
proceeding is
do
going
that
on.
one, my lord. That's
Anyway,
not a
what I'm
reason, my
saying
lord.
is, if the points are threshed out, then
Gotcha.
we'll close the matter.
Gotcha.
We are not saying that, okay, this much we heard today, another
No.
day will,
No.
that will not be possible.
Well, I'll join
So
back.
you
Let
have
me
to
see.
tell them that. the
No,
court
that
proceedings are-
I'll do it, my lord. My lord, my senior will start up. I'll come and I'll also finish up. There is no problem. Only, my lord, half an hour, 1 hour, I'll just, by the time my senior will finish.
That is okay. That is okay.
Yeah.
Yes.
yes, my lord. Lord, here, the first predicament which I find here is there is no,
Which is the paper book you want to rely on?
my lord, the appeal 5,
Appeal 5.
5.
Right. Yes.
The issue has arisen out of the appointment made to the post of Secretary to the Chief Justice, Honorable Chief Justice, which post was initially filled up in officiating capacity by my client. And then, after more than 2 years, he was regularized against that post. The writ petitioners who are otherwise eligible to be considered for the post of Secretary to the Honorable Chief Justice have come up. Firstly, by filing the first writ petition challenging my appointment as the Secretary to the Honorable Chief Justice in officiating capacity. That was put to challenge. Subsequently, when I was regularized against that post, they have filed another writ petition challenging that regularization. And the learned single judge has held that the Honorable Chief Justice could not, if I'm correct, my lord, we'll see, my understanding is the learned single judge has found that probably there were better candidates who could have been selected. This choice is not proper. That is, my lord, in Maharaj's full submission. They're very tenor, if I can understand it correctly. But fact remains that this is judicial review. This honorable court will see only the procedure in making the decision, not the decision itself. Also, fact remains that there is no clear set of rules framed by this honorable court till date laying down the procedure as to how selection is to be made for the post of Secretary to the Honorable Chief Justice. That is an admitted push. The practice which has been followed consistently till now in filling up those posts, the same practice has been followed this time also. Therefore, the question that if a selection is made by following that process, that practice, whether there is a reason to say that this is unfair or improper, or that while doing that, proper choice could not have been made. That is the very essence of the finding of the learned single judge. Then we will have to examine, therefore, under that pretext, also the question, how are the petitioners are affected, to what extent, because there is prima facie no select list, nothing. If it had been the case that selection was made and a select list was prepared, our names appeared there, then matter would have been different. Here it is not there. So one can ask the question, if I may ask myself, that had I been selected, had this particular procedure been followed, probably I could have been selected. And so I had a case to challenge it. Well, in my school submission, that by itself will not give them a right to claim that the entire selection is bad. Therefore, under this background, I will take your lordship to the first impugn order. Lordship will see what was the impugn order they put to challenge. At page 117, and that's 143, sorry, 143. This is the order dated 2nd September 2016. One 43, my lord, is the first post, the protocol officer. We will go from that stage, my lord. The post of protocol officer was first filled up with me, and from that I climb up to the post of the Secretary to the Honorable Chief Justice. Here, lordship will see Annexure D 143. Notice, this is a notice dated 2nd September. Options are hereby invited from the intending senior judicial assistant of this registry for filling up of one vacant post of protocol officer in the principal seat of the Guwahati High Court in the pay band of such and such, plus grade pay of rupees such and such per month, plus other allowances as admissible under the rules. Preference will be given to those senior judicial assistants who have completed 5 years of service. The selected candidate for the post of protocol officer will maintain his or her seniority in the original cadre, and his or her further promotion will be considered on that basis. Lordship will note this particular clause. Willing candidates may submit options mentioning their service profile to the AOJ establishment on or before 17/9/2016. So this was a notice inviting options. That is the procedure. That is the rule. Inviting options from the persons holding the post of senior judicial assistant. If they're willing, they can opt for. And options were asked for.
Yes.
And then options were given by intending candidates, including me. And ultimately, I was selected and I was appointed by the Honorable Chief Justice. Next page, Lordship will find the order. Page 144, dated 26 November 2016, in exercise of the powers conferred under Article 229 of the Constitution of India, read with Rule 6 of the Guwahati Rules, Conduct Rules 1967. Honorable Chief Justice has been pleased to appoint Sri Nirut Sharma, Senior Judicial Assistant, temporarily and until further orders as Protocol Officer in the principal seat of the Guwahati High Court at Guwahati in the pay band of rupees such with great pay of rupees such per month plus other allowances admissible under the rules with effect from the date of his joining. Vice Sri Diganto Goswami, Protocol Officer, released from High Court service. Sri so-and-so will maintain his seniority in his original cadre, that is Senior Judicial Assistant, and his further promotion will be considered on that basis. What was repeated in that notification that has come here also while I was appointed. I will come to its implication little later, my lord. Now, Lordship has seen that there was a condition mentioned here saying that my seniority shall be maintained in the original cadre. Nonetheless, this is an independent appointment to a specific post, upgraded post, which amounts to promotion. Now, page 145, Lordship will see. It was on 10th September 2018. In exercise of the powers conferred under Article 229 of the Constitution of India, Honorable Chief Justice has been pleased to appoint Sri so-and-so, Nirut Sharma, Protocol Officer, temporarily and until further orders, as Secretary to Honorable the Chief Justice on officiating basis in the principal seat of the Guwahati High Court in payment so-and-so, great pay so-and-so, plus other allowances as admissible under the rules with effect from the date of his assuming charge. So-and-so shall maintain his seniority in his official cadre, in the original cadre, that is Senior Judicial Assistant, and his further promotion will be made on that basis. Lord, I have been taken to the post of Protocol Officer by following the due process. I was found to be fit, suitable, eligible and suitable, and therefore I was appointed there. That was a substantive appointment in my response submission. That was a substantive appointment. But a clause was inserted that I will maintain my seniority in the lower grade. When there is no such provision in the rule. That part, Lordship may note that there was no such provision in the rules. Nonetheless, yes, at that time I didn't challenge it, I accepted it. I have no bargaining power. Lordship will kindly appreciate it. I have no bargaining power. The authority has appointed me, I have joined it. But my joining in my response submission will not convert something illegal as legal. No, that is not the law. Therefore, I join. I continue. Thereafter, having been satisfied with my service, the authority appointed me as the Secretary to the Honorable Chief Justice. And there also, what was the rule followed? What is the procedure followed? Procedure was that the registry shall put up the profile of all the eligible candidates before the Honorable Chief Justice, those who come within the zone of consideration. Their cases will be placed before the Honorable. It is in-house, filling up the post, placed before the Honorable Chief Justice, and Chief Justice will choose a suitable one from amongst them. And having exercised that power, the Honorable Chief Justice appointed me, have found me suitable and appointed me. At that time, it is not the case that the cases of the other eligible candidates were not placed before the Honorable Chief Justice. It was not the case. Case was that the cases of all the eligible candidates, the pool of officers who are entitled to be considered for the post of Secretary to the Honorable Chief Justice, their cases have been placed before the Honorable Chief Justice, and the Honorable Chief Justice had to make a choice. It is his discretion. And having applied his discretion, applied the mind fairly on those candidates who have been placed before the Honorable Chief Justice, this Chief Justice found me as suitable and appointed me. But I was
Is it a
appointed.
cadre post, secretary to Chief Justice?
Cadre post.
Is it a cadre post?
Protocol officer is a cadre post. Secretary is also a cadre post.
What is the procedure for filling up that post?
That, my lord, procedure is, as has been revealed by the High Court affidavit, only the all eligible candidates who are, my lord, all have been to be placed before the list of candidates who are eligible to be considered for the post of or eligible to be
So it is a selection based appointment.
selection-based appointment, not open selection, but the cases, all the profiles as I submitted, the cases of all the eligible candidates have been placed before the Honorable Chief Justice, and it is the Chief Justice who is to make a choice out of them. That is the only practice and procedure followed here. There is no specific rules laid down. Nothing. Therefore, this choice was made. And while appointing me, then I was appointed as in charge, officiating basis. My appointment was initially made on officiating basis. They put to challenge that, saying that the selection procedure has not been followed. Is it the case? Right? Their case is that my case could not have been considered because I could not come within the zone of consideration for that post of secretary. Because they say
Not come in the zone of consideration for the post of
secretary to the Honorable Chief Justice. I could not have been considered for the post of secretary to the Honorable Chief Justice because I do not come within the zone of consideration from the feeder post. I have not come from the feeder post.
What is the feeder post?
That their ground is because I was appointed as a protocol officer. Nonetheless, the post of protocol officer is the feeder post for the post of the secretary to the Honorable Chief Justice. But since my appointment letter maintains a condition that my seniority shall be maintained in the original cadre in the senior judicial assistant, therefore, my appointment was temporary appointment. It is not a substantive appointment, and so I do not have the right to be considered against that. I could not, my case could not have been taken up for consideration for the next higher. Therefore, that is their first case, and therefore, contention is that eligibility, I lack eligibility, and so I could not have been considered. My appointment to that extent in both the capacities, initially as officiating, then in regular basis is illegal. That is the only case. That is the case. Now, therefore, your lordship shall have to see whether my appointment to the post of protocol officer can at all be said to be a temporary appointment. I am not holding the post in substantive capacity so that I cannot claim the right to be considered for promotion to the next higher post. That is the good question here. That is the good question,
My lord,
which
I'm sorry to interrupt, my lord, with the lordship's kind permission. Now, this is a point he cannot raise in my petition. Even for the sake of argument also, this should not be permitted.
but
that
that is
is-
finding
no,
this sort of
no, no.
language single justice the right.
No. If you want to say that that condition in that appointment letter of protocol officer was wrong, you have not challenged it, you have accepted it. It doesn't lie in your, no, lordship will not even permit to argue this point.
No, I'll come to it. I'll reply to my legal friends. I'll reply to it.
That was argued by me and if that was dealt with by the Honorable Singh.
The point was thrust out. The point was raised on behalf of the High Court also. That was dealt with by us, and the learned single judge has also answered that question. Answered that question. I'll take your lordship to that. Question is, Malak, as I submitted initially, their objection is I did not put a challenge to that condition. Is it all the time required? My question is to myself, am I to question it? If it,
That aspect of the matter has been dealt with by the learned single judge.
yes, learned single judge has said that my appointment to that extent, protocol officer, I am holding only on temporary basis, not on substantive basis. Therefore, I do not have the right. That is the foundation. That is the final. My Lordship will appreciate law, certain law is that if something, some condition has been incorporated in the appointment letter, which has no legal standing, that will not bind me.
No, just a moment, Mr. Monta. Protocol officer is a post, is a substantive post under the rules, is it? Now, the pay scale is different for
Yes.
protocol officer?
Higher.
Then once an appointment is made to another post, which is a part of the cadre, then the person exits the earlier cadre of
Yeah, exactly.
senior junior and goes to the next cadre.
Next cadre.
Whether temporary or permanent,
Yes.
that is another matter. Then if a person goes to another cadre, then how can his seniority be maintained?
Maintain there. That
Other
is
cadre.
my question. That is why I say. That is why.
Just one small
Yes,
clarification.
yes,
So that
What had happened was, the rules per se don't prescribe a method of recruitment to the post of protocol officer. It was an ex-cadre post at that point of time. In 2011, with retrospective effect, it was en-cadre. But unfortunately, there was no provision made in the rules. And that post was en-cadre in the rank of earlier superintendent, now my lord, administrative officer judicial. So a committee of this honorable court, my lord, met and laid down the procedure as to how this should be done. Now, this was done by my lord resorting that there will be options called from the senior judicial assistants and junior judicial assistants with a particular period of service. And then that will be the my lord persons would be then whoever has given their my lord the options, they will be subjected to a selection process. And basing on that selection process, the person would be appointed to the post of
that's fine.
protocol.
That is the
Now, what had
methodology,
happened, madam?
yes.
Protocol from protocol officer, there is no promotional avenue. This secretary post is not a promotional avenue, madam. From promotion, there is no promotional avenue from the post of protocol officer. It's a my lord, sort of a different department, and you will have to be stuck there. So, in all probability, the court said that the seniority, promotion, and all will be, my lord, considered with your that original cadre. But my
No, Mr. Nair, you are going on to the case of your client. I'm not on that.
lordship,
I'm asking you, supposing in a works department, somebody is appointed as executive engineer by virtue of his or her holding the post of assistant engineer.
lordship,
Once you are
executive.
absorbed in the cadre of executive engineer, how can it be said that his seniority will be maintained in the earlier cadre?
Lordship,
What is the meaning of that?
that's an error, my lord. Maybe
That's an error.
that's an error, my lord. It was an error and it was never corrected. But my lord, my contention before the honorable single judge was, for all intent and purpose, till a person continues as a protocol officer, he must be deemed to be a member of cadre 2C, my lord.
You argue that, let
Lordship.
him finish. Just wanted this small clarification.
Lordship.
So according to you,
My lord,
it is an anomalous.
Lordship's query cannot be only open-ended, my lord. The reason is the analogy which your lordship has given, it all depends what is the nature of the appointment of that executive engineer. Then that question will come. If the appointment is not substantive, then no. Supposing somebody is appointed as an officiating executive engineer, he will maintain his seniority in the assistant executive engineer.
So you are saying that, forget this case.
Yes.
Anybody who is temporarily appointed
Yes.
as a protocol officer.
Yes.
If his appointment is regularized, then his
No, if
seniority-
it is regularized, that's a different thing.
Hmm.
Until it is regularized, he will maintain his seniority in the feather cadre. And my lord, he was the junior most. But it's the question of, my lord, even taking option from him, just now my learned friend has said, he is privy to the High Court records, he can make so many arguments. Just now he said, these options were called for from the senior most senior judicial assistant. His rank is 45. How his option was accepted?
that will see.
That was not the requirement. The person, all the employees who were working as senior judicial assistants, having 5 years practice, I mean the service, they are eligible. So if I have completed 5 years, I am eligible Doesn't matter where my rank stands. I come within the zone of consideration. All those who have completed 5 years, they all fulfill the eligibility and they are to be considered for. And more particularly, one has to opt for. Option was asked for, not automatic consideration. One may not like to go to that side because senior judicial assistant, that post have a different channel of promotion. Now we will have to go to another cadre, which of course carries higher status, higher rank, and great pay. Therefore, options are asked for. So everybody may not be eligible or may not be willing. Therefore, those who are willing, they can only opt for. So I opted for. Along with me, some of them also opted for. But ultimately selection was made. And in the selection process, I came out successful. I was appointed. If the procedure, that is why I submitted, if the procedure for filling up that post was followed regularly and the post was filled up accordingly, then the substantive procedure for adopted in filling up the post will make the appointment substantive because post is not temporary. It doesn't say, Lordship has seen that advertisement, there is no indication that there will be a temporary appointment or that it will carry only for a particular period. Appointment will be not there. Therefore, and the post was permanently vacant. Therefore, when I was appointed, that particular condition was incorporated. That is, even when I know that this may not be a correct proposition, condition may not be legally sustainable, but I had to accept it because I had no bargaining power. I have accepted it. And I could have, had there been an occasion to challenge it, probably it remained all the time for me to challenge it, but there was no such occasion arose ultimately. Because the authority having realized and having been satisfied with my services, ultimately assessing my suitability along with others, found me rather suitable from amongst them. And then took me to the higher post. That by itself shows that authority has ignored that clause. And there was no occasion for me to challenge that particular condition in the appointment letter. And I was subsequently regularized. So therefore, there was no occasion for me to challenge. Without being challenged, even I can argue.
You were
And
subsequently regularized in which post?
in the higher post, that is the Secretary to the Honorable Chief Justice, because the initial post, that is the feeder post of protocol officer, there I was taken as the substantive
All right,
appointment.
now please tell me one thing. Please tell us one thing. What is the qualification eligibility for appointment as
Protocol.
secretary to the Chief Justice?
Secretary to the Chief Justice, Rule 7, Lordship will find. Lordship will kindly take up Rule 7 of the High Court Employees Rules. Sub rule.
It doesn't
Three.
have the basic qualification also. Rule 7.
Rule 7(3) probably.
Having a law degree.
Yes. I'll come to
In
it.
this
Mala.
book, Milord, at page 643.
Page 640?
643.
In this book.
640.
643.
No,
Very relevant
640. 73A.
7(3)(a). Yes.
Oh, sorry, 640.
It's 640, right.
Yes.
Rules for appointment, it starts from 3, Mala, part 2. Appointing authority, that is there.
Degree in law.
Then Lordship will come to page 640, 3A. The Secretary to the Honorable Chief Justice, sorry. The Secretary to the Honorable Chief Justice shall be appointed from amongst the gazetted officers of the High Court Service belonging to Class 2AA, Class 2B, or Class 2C, having a degree in law considered suitable by the Chief Justice. Protocol officer comes under
Plus to see.
class 2C. Class 2C, protocol officer. So, now here, it is considered suitable by the Chief Justice.
This requirement was.
Having a degree in law, this was a required qualification, having a degree in law. I didn't
Appellant
possess that.
Doesn't have.
I didn't
Appellant
have.
doesn't have a degree.
I didn't have. So the Honorable Chief Justice had to relax that qualification while exercising the power.
63A.
63A, the power to relax, Lordship will see. If a power is invested, whether that can be done or not. Rule 69, no?
Rule 63A.
63A. 63A, Lordship will find at 662, page 662.
Yes.
The Chief Justice shall have powers to relax age or qualifications for appointment to the service of the High Court in appropriate cases according to his discretion. This is the power vested on the Honorable Chief Justice.
Absolutely.
So
Therefore, well, what I find, the particular provision of law here gives absolute power to the Honorable Chief Justice. He is to exercise that power in appropriate cases according to his discretion. We all know judicial announcements are there. That discretion leaves the opportunity or leaves the option for the authority to exercise the power for the interest of the institution, for the interest for fulfilling the interest of the purpose for which the power has been given. At the same time, it is also the case that it must not be arbitrarily exercised. As I remember, the particular line falling from the Honorable Chief Justice that time, our Justice came Larry. While arguing a case, in my case, he asked the question to the government, how can you do this? Discretion is not an unruly horse. That was the language I remembered on that day. Discretion is not an unruly horse. How can you do it? It has to be exercised in a just and fair manner. That is how the question is now. To that extent, that was my submission before the single judge also. That whether the Honorable Chief Justice has applied his mind, well, he has considered from proper angle, and what is the procedure followed? That is the only aspect here involved. You cannot question that how can Chief Justice choose him out of all. That in goes to the merit. Election.
no, that you are right. The read code cannot go into
Yes,
the merit of the
I'm
decision.
getful, man.
Decision, what has to be seen is whether the provisions of the rules have been complied
Yes.
with, and for non-compliance, whether it has caused prejudice to any of the parties.
Yes.
That
That
is the
limited
fundamental, area of inquiry for the read court. But leaving aside that, from your submission, what we could understand is that the appellant, that is your client, was serving as a senior judicial assistant when he or his candidature was forwarded to the registry for appointment of a protocol officer
on my exercising option.
on your exercising option.
Yes.
Apart from you, there were other candidates. And then based on the dossiers of all the candidates with exercised option,
Interview was there.
interview was held
Yes.
and the appellant was selected and appointed as
Protocol.
protocol officer. So that is not a promotion. That is
No.
a appointment on the basis of a selection process.
Yes.
Whosoever is eligible
Yes.
and has exercised option has participated,
Participant.
and thereafter a process of selection was held
Well,
and he was appointed.
exact.
Now, because the appointment is against a substantive cadre post,
Yes.
therefore,
Process followed was also the substantive process as laid down.
as laid down by law, your argument is that there is nothing wrong in his
Yes.
appointment as a protocol officer.
Exactly. And they have not challenged it. They have
That
not
is
challenged it.
That is not on the challenge.
Not under challenge.
Then
that
the
was the-
next issue is, would he have been appointed as secretary to the chief justice? Now, there also, this post of secretary to the chief justice is included in the rules,
Yes,
but there is no procedure prescribed for appointment or
Yes.
filling up that post.
exactly,
Is that your argument?
exactly.
So the chief justice examined the candidature of a number of candidates internally
Yes,
and found the appellant to be most suitable.
suited.
Therefore, by relaxing his
Yes,
qualification norms,
qualification.
he was appointed on officiating basis.
No, obviously, no, that time, no, it was not done. He was only officiating. The relaxation was done at the time of regularization.
All right.
Subsequently, after more than 2 years.
But he has not yet been regularized in the post of protocol officer.
No, not necessarily, but because that no regulation is required because this was not a temporary or officiating capacity.
No, but order says it was a temporary appointment.
Temporary ward that will not convert, my lordship will appreciate. In so many orders, in administrative departments, they issue orders saying that you are temporarily appointed or your appointment is temporary until further orders. This remains. But that does not convert it unless the process is not followed. Unless the process of selection and appointment is not substantively followed and appointed. Or the post is tenure post for a particular period, then one cannot say, even on temporary post also, there can be substantive appointment. Lordship will appreciate that in a cadre, suppose in the cadre of assistant engineer, there are 10 regular posts, permanent posts, and another 5 temporary posts. Those are taken as temporary. Those temporary posts are filled up by following the due process. Then they hold the post in substantive capacity. Just hold the post in substantive capacity. Therefore, here also, post was regular post, permanent post. It was advertised accordingly and filled up by following the due process. But
All right, let's move
condition
on then.
mentioned.
Where is the order of its regularization as?
as the Secretary to the Chief Justice, that lordship will find
Is 71, 72. This quoted in the imperial judgment.
here पर देखो सुन यार यही तो कोड है here मतलब here your lordship will find it at page 146. Let us first see the order of regularization, then I will take your lordship to the other part. At page 146. Lordship got it, my lord?
Yes.
Yes. It ordered dated 24th August 2020. In exercise of the powers conferred under Article 229 of the Constitution of India, read with Rule 63A of the Guwahati High Court Service Appointment so rules, Honorable the Chief Justice has been pleased to regularize the appointment of Sri Nirut Sharma as Secretary to the Honorable Chief Justice with effect from 4/7/2020, which was made with a registry notification number so and so dated 10/9/2018. That is the regularization order.
So why it is regularization from 4/7/2020 while he was appointed on officiating basis on 10/9/2018?
10/9/2018, I was first appointed.
Yes,
And with effect from 4/7/2020, I have been regularized.
yes.
Chief Justice processed the office note on 4/7/20.
My lord, the Chief Justice considered my case. Matter was placed before the Honorable Chief Justice for filling up that post on regular basis. And the Honorable Chief Justice had the occasion to consider it and take the final call on 4/7/2020. Passed an order to that extent. And therefore, from that day, it has been given effective.
Page 170.
That your lordship will find that has been quoted by the learned single judge in the judgment, your lordship.
We'll go to the judgment. Now, after this, what happened?
I'm walking and then they put the challenge, the challenge.
All right, so this is also under challenge,
Yes,
24(8).
This is also under challenge.
So in the writ petition, all these 4 notifications have been challenged. Which are the
Two,
notifications?
two.
Which are the 2?
This at page 146 and at page 145. 145 first writ petition challenging my officiating appointment.
So nobody has challenged the appellant's
Protocol.
appointment as protocol officer
That was not put to
and
challenge.
regular. That is not challenged.
They only argue that because of that particular condition mentioned in the appointment letter, that I will maintain my seniority in the lower cadre. Therefore, it should be considered to be and a temporary appointment. I am not absorbed substantively against that post. I am not a member of the cadre, so I could not have been considered.
So learned single judge has set aside the order dated 24/8/2020. Is it?
Yes,
Which orders have been set aside? Only this or any other order?
Setting upon personal 10-9.
both.
Yes.
And the rest 24th August 2020.
That is the
Regularization, both.
So after the order of the single judge, his appointment as protocol officer is not disturbed. That is not disturbed.
No, that is there because meanwhile, my post in the cadre of senior judicial assistant, that has been filled up meanwhile. That has been filled up meanwhile.
So that's kind.
Yes.
What I'm saying is the judgment under appeal
Yes.
does not in any way disturb the appellant's appointment as a protocol officer.
Yes.
Is that correct?
Yes.
Seniority we'll see later.
Yes.
But it does not disturb in any
No.
way.
Right.
Now, what is the ground on which this officiating appointment as secretary and subsequent regularization, what is the ground on which it has been challenged?
My lordship will see, they say that as I do not belong to that cadre of protocol officer, substantively, my appointment was temporary, so I was not eligible to be considered for the post of secretary to receive.
Why is it so? Is it necessary to be a protocol officer to be considered for secretary chief justice? Is that the requirement of the rule?
Yes, protocol
Where-
officer, protocol officer belongs to class 2C
Cease.
and he is eligible to be considered for the post of secretary to the chief justice. He is eligible. Now, they are now arguing without challenging my appointment there. They are saying that because my appointment was temporary, I do not hold the
So,
post.
in other words, are you saying that had the appellant's appointment as protocol officer been regularized, they would have no case? Is that
They
the
would have
position?
no case.
Is that the position?
And that is what they say. They have not challenged it. And my contention is that this appointment could not have been treated as a temporary appointment. It is a substantive appointment, not standing that particular place.
That is your argument.
Yes.
Your own statement of facts.
Yes,
If had the appellant's appointment as protocol officer been regularized by a formal notification in the post of protocol officer, are you saying that the entire basis of that challenge in the writ petition would have gone? Is that your contention?
yes,
Yes or no?
yes. No, because they have, question is, they have not challenged it. Had they challenged that I could not at all have been appointed or I have been regularized, I do not know, they would have challenged it or not that time. But then my response
Mr.
submission
Mohanta, please listen to the query.
is, yes.
What is being asked is something different.
My lordship, if I can understand,
Yes,
let me,
let me reframe it
yes,
because these are very subtle issues. The query is, had the appellant, means your client, had he been regularized by a formal notification in the post of protocol officer
yes,
pursuant to his temporary appointment, are you saying that the entire basis of the challenge made to the notification dated 10/9/2018, followed by 24/8/2020, would have been taken away from the proceeding? Is that your stand?
no, my lord, question is, since, if I can understand it, my regularization, if challenged if challenged, then I would have been ultimately, let us take it that I am ousted from that. It is held that my regulation is improper or I could not hold that post. Then there is no question of my promotion or appointment to the higher post. That is my understanding.
Protocol officer was not a temporary appointment, so
Therefore, they could have challenged it, saying that protocol officer's post could not have been given to him. Because it is not given on substantive capacity. It cannot be construed to a substantive capacity.
Mr. Nair may be having something to add before you leave
If
for
it is
the.
regularized,
Yeah.
they will have no case, my lord, otherwise.
So that's what I'm asking.
They
Is
will
that the
have no case.
position? They would have no
No
case.
case.
Now, the question is therefore, I think we are well within our legitimate right to ask.
Lordship,
What is the harm in regularizing his appointment? in the
there is
course of-
no harm,
Why
my
have
lord,
you not done it?
only because there is a committee noting
Yes.
that this will be the manner in which it is done. The others, my lord, that was never reviewed. That was a temporary ad hoc measure
Even
then, my lord.
today,
We can be done, my lord.
what is the harm? What is the bar? What is the legal bar for that?
There is no legal bar. my
Because
lord.
they have not challenged his appointment
No,
as
my lord.
protocol officer.
No,
What
that
the-
is why, my lord, my submission before the honorable single judge was the process for appointment being followed. There is nothing in rules. Process for appointment being followed, the post being encadred, the post being permanent, that appointment is substantive for all intent and purpose. And he is a gazetted officer.
Why have you then made it temporary and then not made it permanent?
My lord, unfortunately, at that point of time, this was done, but that was never rectified by the registry, my lord. There was no occasion. This, only when these matters came up, this have come. Now it has come to the notice because of the pendency of the matters. Things have not been come, my lord, not been taken forward. But my lord, the only requirement for the post of secretary is that the person must be an incumbent in the cadre of grade 2C, 2A, 2B, and 2C. If a person is held to be an incumbent in that cadre, my lord, presumed to be an incumbent in that cadre for that particular period of time, then while the consideration is made, my lord, his case will be considered. Then what the registry does, all the three cadres are there, my lord, which is eligible for being considered.
No, that's correct. It's not strictly on the merit of this case.
No.
We are asking a general question.
Lordship is much.
You have selected someone and appointed
Lordship.
him or her against a vacant post, which is a cadet post, which
Lordship.
carries a higher pay scale.
Lordship, gazetted post.
Gazetted post.
Oh.
You don't regularize him in that post. You don't care to-
Unfortunately, my lord, that was not done, my lord. Unfortunately, it was not done. I had a discussion, my lord, nobody, they only gave me, but that notification, that decision of the committee subsequently was, my lord, not taken into consideration. And my lord, one more factor, my lord. These people are placed before the Honorable Chief Justice. Every records, ACRs, details, everything is placed before them. The Honorable Chief Justice then, my lord, examines. Because it is his secretary. It's a post, my lord, not equivalent to any other post in the registry, my lord. It's a different post. Then he picks up a person, my lord. I'm deliberately using the word pick up, my lord. On consideration, he chooses a person, my lord. And then he appoints him. Here in this case, Niroj Sharma was chosen by the Honorable Chief Justice. And my lord, at that point of time, maybe because the Chief Justice did not have much access, he was satisfied with that man, but he wanted him to be tested further. My lord, this man was taken up on officiating basis. Now, interesting point, my lord would see, the post of protocol officer fell vacant. That cannot be kept vacant. Now, that post was filled up again on officiating basis, not on temporary basis, my lord. Because he had a lien there. Once the Chief Justice found that he was, after examination, found that he gave a detailed note, my lord. There is a detailed note to that effect, wherein the Chief Justice application of mind is revealed. After the regularization order was passed, the post of protocol officer was again filled up on temporary basis. There is a differentiation. Officiating, now because he has a lien in the post of secretary, that post was filled up, my lord, on regular basis, my lord. Same thing, seniority will be there, but regular basis. Now, this matter was put to challenge before this honorable court. This honorable court, honorable single judge, my lord, there was a move now for consideration of his case for promotion to deputy registrar. That was, my lord, put at a hold. Then the whole writ petition was, my lord, heard. My contention before was, my lord, that if he is an incumbent in 2C, which he is for all intent and purpose, then he comes within the zone for consideration by the Chief Justice for appointment as his secretary, which was done. Subsequently, my lord, the order was passed, wherein, my lord, on consideration of all aspects of the matter, and also by relaxing his educational qualification, that is that law degree, he was directed to be regularized, which he was subsequently in the month of August. Done, my lord. Honorable single judge, my lord, proceeded on a premises that the Chief Justice, the observations that were given by the Chief Justice are not enough. Sufficiency was gone into, my lord, which, my lord, unfortunately, I can straight away place it. Sufficiency was gone into. Then it was said that there was a reference in the Chief Justice's note that earlier incumbent in the post of secretary, one Sailendra Chaudhary, who was, my lord, a private secretary, he's also did not have the law degree, and his also law degree was condoned. The honorable single judge draws an analogy saying that the case of Sailendra Chaudhary and Niroj Sharma cannot be compared. Why? Because Sailendra Chaudhary was a steno, but Niroj Sharma is not a stenographer. My lord, this post does not require a qualification in stenography, my lord. It does not require a qualification in stenography, but the stenographers are also made, my lord, within that zone for consideration. So, basing on these two parameters, my lord, the honorable single judge has interfered with the two orders, saying that the Niroj Sharma can be now reverted back to the post of protocol officer.
All right, Mr. Nair, you see, we'll go a little deeper into the merit of the appeal.
Lordship.
Insofar as the judgment challenged is concerned.
Lordship.
But please tell us one thing.
Lordship.
The promotional avenue in a department, which you know it very well, these promotions are all creature of statute. So promotions will have to follow the statutory line.
Lordship.
Correct.
Lordship.
And whatever the criteria laid down, if it is merit, then of course seniority will take a backseat. But here is a case, you are taking out one employee out of the normal route of promotional avenue, in the sense that you are saying the post of secretary, that is absolutely Chief Justice's discretion. So he can pick up anyone. Only thing is he has to fulfill the requirement, the eligibility criteria. That's very good.
Or he should be in that zone of the cadres which is specified.
So somebody gets a quantum leap.
Lordship.
And then you are again bringing him back to the normal channel of promotion. So will it not generate heartburning amongst the others?
My lord, when he was picked up for secretaryship, initially, my lord, he was given on temporary basis. The Honorable Chief Justice discretion, he gave it on temporary basis.
No, Mr. Nair, I'm rewinding it a bit. And I'm putting a very specific question.
Lordship.
In every organization, in the promotional route, either you follow the seniority or you follow
Merit.
a very well laid down criteria, which is universally applicable. It could be either merit with reference to seniority or vice versa. If it is merit, then you follow a criteria which is, whoever is the best suitable candidate goes it. But the office of Secretary to Chief Justice does not follow any of the criteria meant for promotion.
Lordship.
It is just amongst every choice available, I'll pick up anybody I like. Very good. The Chief Justice has the discretionary power to do that, and there may be some justification.
Because of the nature of the post.
But in this process, someone who is in the bottom of the list in terms of seniority may also get a quantum leap.
Lordship.
But thereafter, you are again bringing him to the normal channel. So he takes a frog jump over the other employees several times. And then he suddenly acquires eligibility for a higher post,
Lordship.
which in the normal course he would not have.
He would have.
So how does the rule address this issue?
My lord, this issue can be addressed in this manner, my lord. My lord, I'll just take 2 minutes. My lord, in a normal departmental scenario, there are 2 types of, my lord, elevation. I'll use the word elevation, my lord, or upgradation to a higher post. One is promotion, my lord. One is absolutely promotion, either seniority or merit.
All elevations may not be promotion, Mr.
That's true. That's true. Other than that, status of, there are in service jurisprudence or services posts which does not have a feeder cadre for purpose of promotion. In this post, normally, my lord, posts are filled up from a designated area or cadres by exercising options, which is the post of protocol officer here, my lord. Now, once that option is given, my lord is saying that what happens to the others? Say, my lord, there are 100.
You're not saying that. It's as simple as that. You can take someone to be your secretary at your discretion. That's well understood. But once the Chief Justice changes, which is a continuous process, that person is conferred with a permanent benefit. He cannot be reverted from the post of secretary. It is not about X, Y, or Z.
No.
It is about a general statement. He gets an elevated position because a discretion of a particular Chief Justice favors that. But after the Chief Justice leaves, that discretion remains permanent. And it gives him, it changes his condition of service.
True, man.
Gives him a frog jump.
True, man.
Gives him a quantum leap.
True, man.
This is an irreversible
It's an irreversible
benefit
process.
given to him.
Lordship.
But the process and justification for doing it appears to be completely temporary. That I like him, so I think he's suitable.
My lord, for that, my lord will have to, there has to be an exercise by the registry to amend the rules, man, to that extent. Now, the rules as it stands today, my lord, a JA or a SA, my lord, a judicial assistant, junior assistant, and a senior assistant, they are given options. If they have 5 years of service, they are given options whether you want to become a protocol officer. Now, my lord, will see there are 100 people, my lord, in JA and SA together. 100.
Protocol is not the issue.
No, that's, I'll try to place it, my lord. That is the way the catch is, my lord. Now, once 100 people have been given the option that come on, give up your options, only 7 opt because of the adverse nature of work involved in the post of protocol officer. Well, it's an admitted fact. The protocol officer job requirement and that of a JA and a SA is totally different one. 7 people or 8 people apply and they are interviewed, put to a selection process, wherein honorable judges of this honorable court are part, and then a select list is prepared and the person is appointed. Now, appointed against what post? Appointed against a post created in 1999, ex-cadre, brought to the cadre in 2011, given permanent status. Now, while appointing it, because some committee had said that you appoint them in this manner, options and all, but their seniority will be counted in the cadre of JA or SA wherever they are for further promotions. Now, there can be 2 reasoning for this one. One was this was done just to meet the situation that was arising therein, or 2, this was done so that, my lord, a person who is there in the protocol officer, a protocol officer who is there, my lord, he does not have any avenue of promotion. Secretary is not an avenue of promotion, my lord. It's not an avenue of promotion. It's not a promotional avenue that a person has, my lord. It's a, my lord, a post wherein a direct recruitment can take place. Now, this man, this protocol officer does not have a promotional avenue. So, my lord, his seniority is been fixed here because the post of protocol officer is equivalent to superintendent. That means, my lord, today, administrative officer, judicial. So, SA gets promoted as, my lord, as assistant officer, judicial. Then, my lord, his next promotion is assistant registrar. So, this man would be given a, my lord, he'll not be stagnated here for his whole life. He can give an opening. Now, but for all other intent and purposes, pay, status, responsibilities, duties, he is a protocol officer, my lord. Now, the requirement, my lord, this confusion can be, my lord, set at rest.
So are you saying that this particular person, the appellant here,
Lordship,
he can be again sent as protocol officer today?
if my lord today, my lord is not entertaining the appeals that we have filed and the order of the honorable single judge holds the field, he goes back as the protocol officer because that's the order of the honorable single judge also. Because, my lord, that for all intent and purpose, he is a protocol officer. And if he is a protocol officer, if my lord declares that for all intent and purpose, my lord accepts my argument, then my lord, the discretion exercised by the Chief Justice, my lord will see page the note given by the Chief Justice, then my lord, that appointment cannot be interfered with.
So secretary has a higher pay scale.
Higher pay scale, my lord. Higher pay scale. It's a higher pay scale. It's in the rank of
My lord,
assistant.
I'll just clarify. The honorable single judge has not said that he should be sent back as a protocol officer. My learned friend has made two wrong statements by now. Now he was referring to the learned single judge's finding. Please come to page 177, my lord.
The respondent number
Why-
5 is therefore required to be reverted
Or
to the post of protocol
or
officer.
substantive post of senior judicial
Ah.
assistant.
If
He
the
has
High
the
Court
habit
so
of misleading every time.
It's there in
No, you are misleading the court. One more para, my lord. Please come to para page 173. He said the learned single judge
Right.
took the view in case of Shailendra Chaudhary because he was a stenographer. He haven't said that learned single judge took the view because he was in the feeder cadre of class 2 CD. Please come to 173.
Mr. Chaudhary, we'll hear you.
No, my lord.
Details.
Wrong statements are being made. That's why I had to stood up. I
We
was
have not
listening to
taken
you.
note. We have
Yes.
not taken note. All right. Let-
It's not fair.
My lord, the order is the respondent number 5 is therefore required to be reverted back to the post of protocol officer if the High Court so desires, or to his substantive post of judicial assistant. To avoid causing prejudice to the respondent number 5, it is provided that the persons below the respondent number 5 in the gradation list are promoted to any higher post. The respondent number 5 may also be considered for the same by giving retrospective effect so far as notional benefits are concerned. So, my lord, it's there that he can be reverted back as protocol officer, and if the High Court desires, then my lord, either way.
And protocol officer is a feeder cadre for the post of assistant registrar.
No,
So then-
no,
Then
no. Protocol officer is an independent cadre. There is no avenue of promotion. My lord. Secretary post is in the rank of assistant registrar, my lord, in terms of our rules. My lord will only have the rules for the moment, my lord, 638. My lord will have 640, my lord. Mm,
640.
40. 3A. My lord will see the wording, my lord.
Hmm.
The secretary to the Honorable Chief Justice shall be appointed from amongst the gazetted officers of the High Court service belonging to class 2AA. 2AA, my lord, is,
Where is the table?
my lord, at 664, my lord. My lord will have that 644, class 2A, librarian cum research officer and senior private secretary. Then the next is class 2B, which my lord would find at 665. Private secretary, grade 1, private secretaries. Then, my lord, grade class 2C. 2C starts with administrative officer judicial. Then, my lord, stamp reporter.
Mr. Nair, would you please ask Mr. Das to quickly get an instruction, if possible at 12? Was the appellant considered for promotion to the post of assistant registrar ever in near future?
No, my lord, he was considered for the post of deputy registrar, and that is, my lord, kept in seal cover. My lord. That's my
Deputy
instruction. Deputy registrar, and that is kept in seal.
And that is by virtue of his
Status as secretary to the Honorable Chief Justice, because it is in rank 2A, and deputy registrar is filled up from this rank, this category. And my lord would come to that 2C. Administrative officer, judicial, stamp reporter, court officer,
so
protocol.
therefore, Mr. Nair, assistant registrar is a promotional post.
Assistant registrar is a promotional post from that of administrative officer, judicial.
And secretary is a selection post.
Selection post. Secretary, my lord, there is no promotional evidence from any cadre to secretary. It's only 3A at page 640, which says, I'll just place the wordings before my lord.
Yes.
The secretary to the Honorable Chief Justice shall be appointed from amongst the gazetted officers of the High Court service. I'm a gazetted officer, my lord.
or belonging to class 2AA, class 2B, and class 2C, having a degree in law, considered suitable by the Honorable by the Chief Justice. So, my lord, any gazetted person working as a gazetted officer in either of these three categories, their case can be considered. Their cases are placed before it's nobody's case, my lord, their cases were not placed. Their cases are placed before the Honorable Chief Justice, and then the Chief Justice, my lord, takes a call. Here in this case, it should have been the regular appointment in the word go. The Honorable Chief Justice desired that first it should be we'll examine, found him suitable. There is a note, that note, my lord, will only have 1 second, my lord. That note is quoted it's before my lord in the judgment. My lord comes to page, my lord is holding writ appeal number 5. My lord may come to 172, my lord. It's there in the records also. This note is 47/2020. Order in reference to page. There was a note put up in reference to that. This note was given, my lord. Considering the consistently good work done by so-and-so, while attached with various Chief Justice as depicted from his ACRs, the efficiency, integrity, punctuality, dedication towards duty, without taking break, knowledge of computer application, thoroughness in performance of all tasks, searching judgments, preparing templates of judgments, quality of interaction with officers, officials within the institution and of other institutions, confidentiality maintained by him, his good differential behavior with the register as observed by me during his attachment as Secretary to the Chief Justice. That Sri Sharma has attended office every single day of my tenure as Chief Justice of Guwahati High Court from 9:30 AM or earlier if required till late night. The earlier precedents of Sailendra Chaudhary. The absolute discretion vested with the Chief Justice to appoint suitable person to hold the post of Secretary of the Chief Justice. Power vested with the Chief Justice under Article 22-29 of the Constitution of India in this regard. The law laid down by the Supreme Court of India is referred to in the note. The fact that Mr. Sharma has been serving on temporary and officiating capacity, basis as Chief Secretary to the Chief Justice of Guwahati High Court for the last over 2 years, and in case of such sensitive post, ad hocism is not good for managing and administrating the Secretariat of the Chief Justice. I therefore, by virtue of powers vested under 229 of the Constitution of India, read with Article Rule 63A of the Guwahati High Court rules, exercise my discretion, relax the qualification for appointment to the post of so-and-so, and regularize the appointment of Nirod Sharma as Secretary to the Chief Justice, Guwahati High Court. So, my lord, the Honorable Single Judge, my lord, thereafter noted at para 33, my lord, can be. The aforesaid considerations in the opinion of this court while exercising the powers under Rule 63A of the rules cannot be termed to be adequate. Other than merely stating that the earlier precedents of Sailendra Chaudhary, there is absolutely no discretion regarding relaxation of mandatory requirement of the incumbent to have a LLB degree. At this stage, the honorable records reveal that Sailendra Chaudhary, the earlier incumbent, was a Class 2B officer, stenographer SIM, who was well versed with stenography and typing, and his aspect played a very important role in his appointment as Secretary to the HC. This is never there in records, madam. As per the rules, a post of 2B is a feeder post of so-and-so. In contradiction, the respondent number 5 does not possess any such qualification, and therefore the case of Sailendra Chaudhary could not have been cited as a precedent. There is absolutely no doubt in the mind of the court that relaxation power having been vested upon the so-and-so for relaxing the age or qualification of interest, but whether such discretion can be exercised to do away with an essential qualification is a debatable issue. However, assuming that even a requirement which is mandatory in nature can be relaxed, there should be adequate decision to show that there was application of mind to do away with such requirement. My lord, there is a clear application of mind which is now reflected from this note. What more should be done? My lord, adequacy is not something in a judicial review, my lord, will go into. If there is perversity here, that would have been a different issue, my lord. How can the adequacy be questioned, my lord? That was the grievance, my lord, in the appeal to your lordship. My lord would have 64 also.
means?
My lord, sorry, para 34, sorry, my lord.
Yes.
The court is also of the opinion that the powers vested by Rule 63A which is discretionary in nature, has to be exercised in a reasonable manner and for a situation of necessity. There was no dearth of eligible candidates in the feeder cadre having requisite mandatory qualification to be considered for the post of secretary to the HCJ. There were a number of eligible candidates. There was no occasion at all to take recourse to relaxation power under 63A to give a benefit to the respondent number 5, who is not qualified to be appointed as secretary to the HCJ. My lord, what was lost sight of the fact was that this is not a post wherein, my lord, the Chief Justice, Honorable Chief Justice, is required to make a select list. 1, 2, 3, 4, 5. And thereafter, my lord, appoint. This is a position, my lord. Secretary is a position wherein the Chief Justice's own discretion and own liking would have a play, my lord, because of the convenience required. That cannot be denied, my lord. If that is ignored, my lord, then, my lord, the decision or the judicial review would, my lord, stand up not, my lord, here. If that is factored in, and then, my lord, a conclusion is come. I will have nothing to say. Because here this say, my lord, the specific wording is,
Mr. Nair, again and again, I am saying maybe if we can't conclude it today, maybe you have to address the court on that. Of course, we are yet to hear other side. Mr. Mohanto is to finish. But we accept everything. But this discretion, element of discretion is conferring a benefit to someone. Therefore, if it is not absolutely in consonance with the principles of service jurisprudence, particularly Article 14 and 16,
Yes.
then it will create a problem.
my lord,
Please listen to this.
I got it, my lord. I got it. I'll have to address
You
your
can say, even in other such setups, for example, let's take the case of executive.
lordship.
The chief minister has many secretaries, political secretaries, these, that, and it is his or her discretion to choose and appoint someone. But the fact remains that that is not a permanent position. Tomorrow, if the person concerned feels that no, I'm done with this person, he goes back to his original position wherever. But here, this discretion, this relaxation, this choice brings an irreversible benefit to the person in the setup of the service rules. That position is irreversible. If it was that any protocol officer or any officer is taken as secretary, and once the Chief Justice leaves, the next incoming Chief Justice may either continue or he can be sent back. That is another matter. But here, it is giving him a permanent benefit, right? And that benefit is what? Change in the condition of service,
Lordship.
giving him a better pay scale, and also bringing him in a feeder cadre, which is ahead of, which is above the protocol officers.
Lordship.
So, but for his appointment in the post of secretary, he would not have been eligible for being considered as a deputy registrar.
Lordship.
Correct. So when this kind of an exercise is done, it has to be backed. We may or may not agree with the observations of the single judge. That is another matter. But that kind of an appointment must be backed by sound principles established in the realm of service jurisprudence. And that is where we are interested to hear arguments.
Lordship, I'll place
That
my
is where we want to hear
I'll
arguments.
place my lord my arguments
What
with
is the
this.
doctrine? Some doctrine must be there.
My lord,
It may
here,
be permissible. It is
My
not a
lord is-
doctrine of pleasure.
my lord is looking at subject, my lord, I'll address your lordship on that issue. My lord is looking at this matter from the perspective of the person appointed. I would, my lord, I'm coming to that.
We're not looking at it from the perspective of the person appointment. The whole thing hinges on two small points.
Lordship.
First is, if the registry would have regularized his services, which
Protocol officer.
which perhaps even it can be done even today
Today.
with the leave of the court, then the plank of the
Gone.
case goes.
Gone.
But at the same time, this is a public law remedy. The
My lord,
26 jurisdiction, the court will examine the public law element of the matter. Now, that is the issue that is troubling us. Nothing
Lordship.
else. Nothing else.
Nothing.
Only thing is, he has been picked up without there being a transparent selection process. We agree that the comfort zone of the Chief Justice, the incumbent in the office of Chief Justice, is a very relevant factor. Because if you deny the Chief Justice of this pleasure, this
It would
appointment,
affect.
and it will cause serious impairment.
Lordship.
But here what happens is this doctrine of pleasure is giving him a permanent irreversible right. Therefore, will it not have to meet the requirements of certain principles, transparent principles of
Lordship.
service during the
Lordship.
as emanating
it's a
from
valid
Article
point.
14?
I'll have to address your Lordship on
If
that.
the answer is in the positive,
Lordship.
we'll dismiss the appeal.
Lordship.
That is the only point.
My lord, subject to what my lord, I know
You
is
want to
hard.
go, you can leave.
My lord is also hard pressed. I'll just make one submission, my lord. Just to test, on the next date, my lord will fix it. I'll address your lordship on this 14 and 16 thing, my lord. That I have to address, my lord, because it's a valid concern and
14
it's a big concern, my lord.
The other
Because it will have far-reaching consequences, my lord. Not only for this, but in future also. And my lord will have to lay that to rest. Because this is the highest forum now we have. My lord, division bench, laying down order, it will be guidance, my lord. One. Now, my lord would just give me a thought process. I'll develop on that. Let's say that the AOJ, who is there, my lord, the Assistant Administrative Officer Judicial, the senior most person in the organization, in that feeder cadres, madam. He is picked up by the Chief Justice. No dispute. The rules require that he should be given, that appointment would be a regular one. The same situation, my lord, which is now being envisaged in my service, can also arise in that service of that person, my lord, who otherwise is a law graduate, senior most employee in the organization, picked up by the Chief Justice.
This is not to say that the respondents have not challenged the rules.
No,
Therefore, we are just putting this argument just to balance out equity.
I
Otherwise,
understood, my
there
lord.
is
I
no
understood.
point to this.
No, my lord. I understood. So, my lord, today the law, the situation as it stands, the rules, if it were, my lord, to be worded in a manner that it would be a temporary appointment to the discretion of the Chief Justice, and the Chief Justice post being, my lord, constantly changing, it is up to the Chief Justice to have him, whoever he wants, whenever he is here, my lord. It would have been a different situation. Unfortunately now, or fortunately for the appellant, my lord, Niraj Sharma, the post envisages a regular appointment. I'll give him, my lord has given me a food for thought.
And this rule is not under challenge.
Not under challenge. Not even the protocol thing is not under challenge. And they are only, my lord, contention is that this man going from bottom to the top, our seniorities are getting disturbed. My lord, the superstition, if according to them has occasioned after they were also given an option. That you also opt. You did not want to have that address job done in protocol officer. You wanted to have a seat job. I'm not saying they're wrong, my lord. But option was given to them also. Then this man goes. And thereafter, by virtue of being in 2C, the law is gazetted officer of High Court service in 2C. For that point of time, he was conferred a gazetted status by this court. Both assistant protocol officer and the protocol officer have gazetted status. And being there, his name was placed before the Chief Justice. The Chief Justice examined and got it. Now, I'll have to come back and answer your lordship that question, whether, my lord, it's a different issue that it's not being challenged, it's not there, but I'll try to answer that query of your lordship also on the next date, whenever your lordship is fixing the matter. Otherwise, my lord, going by the tenor and going by the rule that we have, which, my lord, cannot be now read into because it's not under challenge, or read down by your lordship because it's not under challenge. The procedure that has been followed is perfect. For future, my lord, if anything is to be done, that can be always be looked into. But the rules as it stands today, merely because your seniority is being disturbed, because in a merit, my lord, in an option situation like this, it can happen, my lord. Junior most can supersede many people and go, my lord. It's like that limited competitive departmental examination, my lord, wherein the junior most gets an opportunity, he writes well, of all the seniors, he goes, my lord. That cannot be, my lord, raised as a projected as a grievance. I'll come back to your lordship on that 14 and 16.
Mr. Mahanta, you can continue and after that we'll hear Mr. Chaudhary.
No, my lord, why should I give half, my lord? Let him complete, then I'll reply. I'll say something, he'll again say something. Let him complete, then I'll make my submission.
How much time will you take today? You will take first half entire?
My lord,
Because we would like to go through the judgment also.
That's it.
We'll go through the judgment.
Yes,
also.
judgment should be read.
So
And
let
I'll
us
test
have
certain laws.
Let us have a 5-minute break and then we'll continue.
Yes,
yes.
5-minute break and then we'll continue.
yes.
But there is a single bench. Huh?
My lord, I have one submission, my lord.
Yes.
My junior should be permitted to go through the records, my lord. My lord, I'm just making that point very clear, my lord. A projection is sought to be made. We have not challenged that his temporary promotion as protocol officer. Therefore, since he is in 2C, therefore he is in the feeder cadre for promotion or selection to the post of, my lord, secretary or assistant registrar. My lord, our case projected in the writ petition is he's still a senior judicial assistant. The protocol officer is only a temporary officiating appointment. It was nothing beyond that. That is why in both the orders it was maintained that he will maintain his seniority as a senior judicial assistant. Therefore, my lord, we never challenged it. That has not been uttered by either of them, my lord. Lordship has posed the question to them at least 6-7 times. Their reply was it has not been challenged, but they those in the later part of the thing. Because our
No,
our
we have already
averments,
submitted, my lord.
please come to our para 5, 6 and 7 of the writ petition. My lord, we made a very clear, please come to our writ petition, my lord. Just 1 minute. Our writ petition starts at page 34. Please come to my lord paragraph 6 at page 46. Why we have not challenged? Because lordship should have the perspective that it is humbly stated that by notification dated 25/11/16, authorities appointed respondent number 5 as protocol officer on temporary basis at so and so. In this said notification, it is clearly stated that respondent number 5 will maintain his seniority in this original cadre, that is senior judicial assistant, and his promotion will be considered according to his seniority in the rank of senior judicial assistant. So when High Court has taken this stand, where is the question of we challenging that protocol officer? He's a senior judicial assistant. That is our case is you are lying at 44/5 of the seniority list. 44 are above you. You have been picked up by somebody. My lord, if the argument of the High Court is to be advanced, then my lord, you will have to delete this article 14 and 16 from the Constitution. I can only make that argument, my lord. My lord, is it a doctrine of pleasure which my learned friend is arguing? Is he arguing a case of article 310? My lord, Supreme Court has said in so many words what discretion Chief Justice has in such matters. And more importantly, please read article 229. When recruitment is governed by a rule, where is the question of discretion, my lord? Either you have discretion or you have the rule. You cannot have both. Article 229 is the parent power, is very clear. Is the rules of recruitment to be framed by the governor, which will govern this election. And my lord, we all know the principles. Rules of recruitment cannot be relaxed. Merely because somebody is a Chief Justice, he does not enjoy any extra constitutional power. As a Chief Justice, when he does something on the administrative side, his order is same to that of an executive engineer issuing a contract order, my lord. Same order, which is to be subject to judicial review. Well, I'm surprised that High Court has preferred this appeal amongst others. Why High Court has preferred this appeal? High Court also should have some litigation policy, as government should have. Why High Court will throw an appeal just at the drop of it, my lord? What is the wrong? All right, another view is possible. Writ appeal is an appeal in principle. Why your lordships will substitute another view? Maybe what the view which they are projecting is one view, and
But
one
Mr.
view.
Chaudhary, I understand what you're saying,
Yes,
but
yes.
we don't agree with the observation of learned single judge. The reasons were not adequate. Adequacy is sufficient.
No, my lord. No, my lord.
Because-
This is something which has been coined by my learned friend. The learned single judge's purport was never adequacy.
No, that's what the observation.
No, my lord.
Yes, please.
No, it's not.
Please see.
I'll also satisfy your lordship.
Para
It's not.
33, see the second line, adequate word is used. Para 33 of the judgment.
My lord,
second
the
line.
meaning of adequacy has to be called out in the context. the aforesaid consideration in, para 33 minor
Yes,
of the judgment. The aforesaid consideration in the opinion of this court while exercising the power under Rule 63 of the rule cannot be termed as a. When he says aforesaid consideration is not adequate in the context of Rule 63A. That means in the comprehension of the learned single judge, invoking of power under 63A, it should precede by certain exercise. That exercise was not undertaken. That is what the learned single judge has meant. Learned single judge has never meant, my lord, what we normally understand what is adequacy of regions. Sufficiency is an aspect which a 226 will never go into. We are not on that. My lord, end of the day, what was being challenged? The decision-making process. What was under challenge?
and supposing this is set aside, how does your clients get to gain from there?
What, my lord?
How will your clients gain from this?
Of course, if not my client, but somebody, if a proper selection takes place, we can offer our candidature, we'll get a right to participate.
A selection for which post?
All future posts, my lord.
No, Mr. Chaudhary.
Yes.
We are debating to understand. the issue.
Yes,
Go to the crux of the matter.
yes.
Is it
No, my
your
lord is
case-
not deciding an interim matter to pose that question. Lordship is deciding a matter in finality.
No,
A
that's
judgment
fine.
has been learned. I can appreciate when passing an interim order, that could be a relevant consideration.
No, that's not the point.
Hmm.
The point is it the case of your clients
Yes,
that we were deprived?
Yes.
We were denied.
yes.
In what manner?
Well, we have a right of consideration.
Consideration
Even for the selection to the post of secretary to the chief justice,
Hmm.
if a proper procedure is followed, the consequence will be there.
Right?
Is it the case of the High Court that we do not have a locus standi to file this case?
So your clients are all holding posts which are in these two class 2A.
Yes, we are in the feeder gather.
Right. So their candidature was not considered,
No,
never considered.
never. I'm shocked, my lord, at this argument. Are they questioning my locus? We say we are in the feeder gather. He is not in the feeder gather. My learned friend has read 7.3A several times. Let us read that rule. Let us first try to find out whether respondent number 5 is in either of the three feeder gather, and secondly, whether he is a law graduate. Thereafter, we'll come to the chief justice. No, thereafter, we'll come to the chief justice part, discretion part. First, let them satisfy that the first two conditions they fulfill. He fulfilled.
All right. And what do you have to say to this? That technically, this plea that you have taken, that he was not regularized in the post of protocol officer.
Yes.
Is there any technical bar for the authorities to do it with retrospective effect?
No, my lord. No, my lord. If they pass an order, we'll challenge, because that will also be not correct.
So, on
If
merit
they would
is-
have passed an order, we could have challenged that order. How can here is a case, a man is not in the feeder gather. He is not having the required qualification. He is being showered with favor one after another. And the lordships has posed a very important question, which my learned friend has not got it. Your lordship's question was, because of this illegality, a permanent benefit has percolated to him. Now, because of the permanent benefit which has percolated to him, what would be the effect on the other persons who are before lordships who are Article 14 and 16? Had it been a case that this appointment is coterminous, the moment that Honorable Chief Justice has left, he is supposed to also go, he'll go back, that's a different aspect. That is not the position. That's a very relevant question, my lord, in this case. My lord, matter is very simple. If this is the argument which is to be accepted, then my lord, what will tell to Dispur? Dispur will find it very easy, my lord.
No,
No, I'm saying that, my lord. No,
That's
no,
not-
no, my lord. Therefore, when your lordship takes a call in this case, lordship will not make a distinction between a high court matter and
No,
a
that
Dispur
obviously-
matter. Same
there
matter.
is no question of any distinction.
It falls on the
No,
same
no, no,
pedestal.
that never happens.
Yes.
Nobody makes any
No,
distinction.
no, my humble submission is, my lord, here is a case. A person has been appointed as a secretary to the Chief Justice who is not in the feeder cadre, number one. Secondly, he doesn't have the required qualification.
Mr. Chaudhary, let me point out one thing. In that case, perhaps it will be better we shift the further hearing to a date and finish it off
Yes,
in
yes.
one go, because
Yes.
these are some new points which have cropped up today. And perhaps All sides will
My
have.
lord,
to
my
decide.
only request was, my junior should be permitted to go through the records.
No, we'll see.
Yes, yes.
What is the problem? You have a look at the report. Allow him to inspect.
No, my lord, do we normally, there's no
Can
problem. We
you,
have,
can you agree on a, mutually agree on a
yes,
date,
yes, yes.
on a non-miscellaneous date? What is the date you can agree? Mr. Das?
My lord can have it on, no dosar kiba kibi dile na. 16th is a, my lord, Tuesday.
So we'll have it on
Yes, full
16th.
look,
then.
yes, sir. Governor silent. Sir, I got online, sir, I got. No. You know me? Court wants it on, Lordship wants on a hearing day.
16, of course.
16 to kiman hai?
16th bench, yes.
18, my lord.
So Thursday, there is a problem. The bench is only available half day.
Yes, 16th should be better.
Or
Okay,
16th.
Lordship will have it on 16. Huh? Huh? Okay, 16. my lord.
Give everybody's name, hard Mr. K. Montolani, Senior Counsel.
In any case, my lord, there will be a special bench, therefore we'll be having some
As
notice.
well as Mr. U.K. Nair, Learned Senior Counsel appearing for the appellant in so-and-so, Mr. K. N. Chaudhary, Learned Senior Counsel has appeared on behalf of the respondents in both these appeals. Hearing remain included in hearing, remain. Hearing could not be concluded today as such, on the request of learned counsel for both the sides. Let this matter be listed again on 16/5/2023 for further hearing, subject to availability of the bench. So we will debate on these things and see what are the issues.
My lord, only thing is my junior will be permitted to
Yes,
go through the
yes.
record.
Yes, let him go through the record. We will examine it from the point of view of Article 14 and 16.
Basically,
nothing else.
that's the only case.
So please don't go deep into who is the Chief Justice and what is.
No.
That these things will not
No,
be.
my lord, regarding
within
the,
the periphery
my lord,
of
the
the
Supreme
present
Court
rules.
has clarified the scope of discretionary power of the Chief Justice in several judgments, my lord.
No, there is no question of any. See, the appointment was done in accordance with rule
Existing rules.
7(3).
Yes.
That
We'll
gives
confine
the-
to rule 7(3).
That gives the power of suitability to choose suitability
Yes.
to Chief Justice.
Yes.
That rule is not under challenge. So we'll have to see whether the process violates Article 14 or 16.
Yes.
If not, the matter has.
In fact, my lord, there are 2-3 similar cases we have brought. There is one division bench judgment of our High Court, then Supreme Court, 2-3 judgments are there, my lord, where court has clearly explained the scope of Chief Justice's power, my lord.
That is there within that scope, whether it was.
Chief Justice's power means if the power is exercised as per the provisions of the rules, nothing can be
No,
commented.
when we say, my lord, when we say whomsoever Chief Justice finds suitable, now that is not an unruly horse.
That is his argument, but the rule
That is
says.
not the unruly horse.
suitability.
Yes,
Who will decide the suitability?
yes, in what manner?
Who will decide the suitability? Under what parameters?
Yes,
These are all, the rules are silent on this.
silent. Supposing even in a case where it is silent, is the Chief Justice not bound to follow Article 14? Fairness.
That's the
That's
only
the
thing
point.
we are saying.
Yes.
That's what we'll examine.
And my lord, most importantly, Lordship will also have to give a finding on the Article 229 itself. It says, if there is a rule, the rule will take over. Then the question of discretion doesn't come.
Correct, but here is a rule which does not lay down clear parameters.
Even that word
That is
suitable,
what we have
even
considered.
that word suitable, my lord, that cannot be interpreted in the manner as is sought to be suggested by Mr. Nair.
That-
Maybe if this argument is accepted, then it will be difficult.
Chaudhary, arguments.
No, I'm saying if
You
it is
can't stop.
accepted.
And arguments should be free flowing because
Yes.
that is what opens up the debate.
Yes, yes.
So what is a good and acceptable argument? That is a matter to be decided at the end. So we'll continue on 16.
On 16.
Yes,
And let the debates be on these rounds rather than
Yes.
right.
directing it towards any person or
Yes.
any individual. All right.
Should not.
So single bench after 5 minutes.
We have filed the affidavit today, Your Lordship.
Achha. On the prayer of Mr. B. Raman, Learned Counsel for the petitioner, this matter stands adjourned for 2 weeks. The affidavit filed today by the learned
Government advocate.
Government Advocate Assam is tagged with the record of the case. Yes.
Interim order.
Interim order passed earlier to continue till the next listing.
Your Lordship,
Date may be fixed, Lordship.
Next listing, after 2 weeks, yes.
Your Lordship, I'd like to mention item number 11, 12, and 13 of today's list.
Hmm.
Your Lordship, due to paucity of time, it will take some time. May I pray the matters may be listed on 9th of May, Tuesday. Lordship.
11, 12, and 13.
13.
Yes. On the prayer of Mr. D. Boram, Government Advocate Assam made with the consent of the opposite party, admission hearing of these matters stand adjourned. Registered to list these cases again on 9/5/2023.
Oblige, Your
May
Lordship.
please, your Lordship. Lordship, may I pray for listing of a motion matter tomorrow, Lordship? My engagement as Anganwadi worker was cancelled, Lordship. And RSA is also pending and writ petition is also pending,
Yes.
Lordship. I'm deeply obliged.
May I please, Your Lordship. I beg to mention item number 25, my lord. It was listed at the initiative of the respondent, my lord. I have taken her consent, my lord. Matter may be taken up on 23rd, my lord. I was newly engaged, my lord, in this case. On 23rd, my lord. with the-
Item 25.
Item
23rd, we can't give it. You ask for adjournment, how many days you say, we'll give it.
Lordship, may I
Fixed
please-
dates not possible in every case. On the prayer of Mr. J.M.A. Chaudhary, Learned Counsel for the respondent made with the consent of the other side. Hearing of this matter stands adjourned for 2 weeks. List accordingly.
May I please, Lordship, I beg to mention item number 20, 21, 22, and 23, my lord. My lord, in this case, my lord, the item number 21, my lord, respondent filed, my lord, affidavit, my lord, yesterday, my lord. I have received, my lord, yesterday, my lord. My lord, the 4 weeks time is granted for read and affidavit, my lord. I have consent, my lord.
3 weeks time, my lordship, a date may be fixed, lordship.
Mr. L.M. Dehinga, Learned Counsel appearing for the eight petitioners in this batch of petitions submit that a copy of the counter affidavit
Lordship.
filed by the respondents in
Item number 21, Lordship.
item number 21 was received by him only yesterday,
Lordship.
and therefore he be granted 2 weeks time to seek instruction and file rejoinder. Since the prayer is not opposed by Ms. R. Devi, Learned Physician appearing for the respondents, the same stands allowed. Register to list these matters again after 3 weeks as fixed items for admission hearing. This is item
Item number 20, 21, 22, and 23, my lord.
20, 21, 22, and 23. Yes.
My lord, earlier interim order, may-
Interim order passed earlier to continue till then.
Master. please.
Lordship, a possible date may be given, lordship. Because
After
they,
3 weeks as a fixed item, I said.
oblige.
May it please your lordship. Let I beg to mention item number 26 and 32. Mr. M.U. Mondal will argue the case, but due to his
32.
personal problem, he has left
Hearing
the
of
court.
the matter stand adjourned on the prayer of Learned Counsel for the petitioner. Same order. For 3 weeks, list accordingly. Yes.
Obliged.
Please, your lordship, I beg to mention item number 27. Your lordship, the matter has been substantially heard by another court and has been kept part heard, your lordship. It got wrongly listed in this court. I pray the matter.
Does Learned Counsel for the petitioners. 27 and 10. These matters have been substantively heard by another bench, and the matters are part heard before the Court of Justice.
Soumitra Sakya.
That's Sakya. As such, the matter be posted before the appropriate bench. Register to verify and list the matter before appropriate bench.
Much-
My lord, similar prayer in item number 28 as well, it's connected to 27.
Yes, 27 and 28.
May I
Yes.
please, Your Lordship. Lordship, I beg to mention for listing of a
Yes,
pending
Sunday
writ-
for 28.
Lordship, I beg to mention for listing of a pending writ petition, my lord, for admission.
Third week of May, put a date.
Of the
Yes.
May it please your lordship, lordship, I beg to mention for listing of a writ petition for admission, lordship.
Third week of May, put a date.
Similar prayer, my lord, for admission.
Third week of May, yes.
Item 29 on the hearing list, and
Yes.
it's for a small accommodation this week.
Yes.
Anytime in the month of May, your lordships, we also wanted to file an additional document.
Mhm.
If
You are
this-
appearing for
The petitioner, the first matter, along with Mr. Kane Chaudhary also.
the prayer of Mr. You write his name, Mr. R.B. Fukan, counsel for the writ petitioner made with the consent of the other side. Hearing of this matter stands adjourned till, you want a firm date?
Any date convenient to your lordship, sir.
Adjourned for 3 weeks. List the matter accordingly. Yes. 29, 30, 31, is it?
Yes.
Yes. In that case, the same order. Yes, okay.
Grateful.
May I please your lordship, lordship, it is anticipated well, lordship, second time, lordship.
And so now this lordship and the new ground is that lordship and already they have compromised the matter outside of the court lordship. And but there is a apprehension that they will be, the petitioner will be appeared to the police station lordship and the section is non-bailable. So kindly only interim protection may be given and after settlement, everything will come with CD lordship. That is my limited prayer lordship. 380 and lordship, 34 lordship. Petitioner is a mention lordship.
My lord, compromise is not a form of record, my lord, in the petition, my lord.
Only one chance lordship, they have already ready lordship, the type is complete, but
Because-
they will be appear lordship and execute the same
Because,
lordship. Otherwise, the section is non-bailable lordship. Otherwise, lordship and already settled and the settlement amount is fixed only 39,000 lordship. 39,000 is fixed already. Lordship, I have very clearly mentioned in my petition.
What do you have to say?
Lordship, that is what, my lord.
You either oppose or you agree.
My lord,
Rest
because
of
it
the
is,
things are not-
since it is a my non-compoundable offense, my lord, I cannot agree to that, my lord.
Last time it was rejected without calling for the case diary.
It was, case diary was perhaps perused, my lord.
Which police station is
On
this?
perusal of case diary.
Palash
Last
Bari.
time, my lord.
Then we have
Case diary
to
is
call for
perused.
the case diary again
Lordship, they are,
and updated case diary.
lordship,
Let the IO record the statement.
lordship.
Lordship, my limited prayer is lordship and the use appear and they will be executed and everything lordship before the police lordship. And lordship, I am very clearly mentioned in para number 5, lordship, page number 5. And 39,000 is fixed and the petitioner will pay and they all. And perhaps it will come the FR lordship.
Yeah, where is
So
the,
only if protection may be limited prayer lordship till the next date lordship. 39,000 already fixed lordship. And even then lordship, the petitioner will be engaged by the informant again in his work. Misunderstanding lordship, otherwise lordship.
who is the petitioner here?
Lordship,
Last order is page 15, lordship.
No, stolen property, what compromise you do? You have stolen it.
Actually,
Yes, sir.
misunderstanding lordship, the present informant is a contractor and he took work in from one farmhouse lordship for boundary one. And the petitioner was the engaged as a mason. And due to some lordship bill payment and some dispute is there lordship, otherwise.
What about the stolen articles?
Lordship, annual lordship, and he is ready to pay the compensation lordship. And already they have settled lordship and already this and it will be executed before the police lordship. And otherwise lordship, if interim is not there lordship, he could not be appear lordship. Only my limited
All right,
prayer lordship.
take down, heard Mr. F. Hawk, learned counsel for the petitioner. By filing this, also heard Mr. MP.
And
Goswami,
people some lordship.
learned APP Assam appearing for the state. By filing this application under section 438 of the CRPC, the petitioner has approached this court for the second time, seeking clearance bail, apprehending arrest in connection with Palashbari PS case number 76/2023. The earlier petition filed by the same petitioner seeking anticipatory bail was rejected by this court by order dated 5/4/2023, passed in AB 879/2023. Mr. Hawk submits that the petitioner has agreed to compensate the informant for the loss of articles. And to that extent, an agreement is in the process of being signed by and between the parties. Under the circumstances, if the petitioner is not protected by an order of interim clearance bail, then the settlement process will be impeded. Full stop. Mr. Goswami, on the other hand, submits that since the offense involved is non-compoundable, hence the case diary be called for.
Lordship.
After hearing the submissions of learned counsel for both sides, I am inclined to examine the CD, call for the CD fixing 19/5/2000, call for the updated CD fixing 19/5/2023, heard in the prayer of entry and relief, having regards to the facts and circumstances of the case, and as well as the subsequent developments in the matter. It is hereby provided that in the event of arrest, the petitioner, namely so and so, be released on interim clearance bail on furnishing a bond of rupees 30,000 and one surety of like amount to the satisfaction of the arresting authorities, subject further to the condition that within a week from today, the petitioner will appear before the IO for recording his statement. First of, this is the matter accordingly.
Obliged, Lord.
This case will take some time, is it?
Yes.
So, if I take up these other cases cannot be.
Some other date may fix, Lordship. I don't know.
Let it be fixed on 4th May,
Huh? 4th May,
if possible.
4th May will not be possible.
Instruction is second.
11th May, have you received the instruction? Have you received instruction?
Yes, Lordship.
What is
The
the-
liability will be something in around 34 lakhs, Lordship. More than 34 lakhs.
There are 134 workers.
34 lakhs, is it a very big amount?
So Lordship, I mean, thing is that whether a state is liable to pay or the private respondent is liable to pay, that Lordship is to look into. Because all the assets, including the land, everything, the mill, the machineries, everything has been transferred.
Lord,
And the company is still existing. So in that circumstances, whether the under MOU as well as the agreement,
Private respondent is not a party.
not a party, they should have been made a party actually. They should have been made a
every
party.
day your stand is.
No, I'm not giving a different stand at all. I'm not giving a different stand at all.
What happened, it was the public sector undertaking. It was transferred to the private sector undertaking. The section 25 AFF states that when a transfer undertaking is transferred to others, the employees' concerns are entitled to have the retrenchment compensation. That is in the purport of the Industrial Disputes Act. So how these private sector undertaking will pay these things, I don't understand.
All the liabilities, including the employees, their salaries, everything has been agreed to be paid by the private party.
Mr. Dasgupta, why are you not implementing the?
Yes, Lordship, why not?
No, I need to
They are
comply, Lord. Lord, one thing, Lord. If your lordship
they have- Yes.
if your lordship goes to the purpose section, it is very much clear that when an undertaking is transferred from one undertaking to other undertaking, the employer shall pay the retrenchment compensation.
But we'll implement the other side. We want to hear their stand before passing. the
Yes,
matter.
Lordship. They cannot sit tight, Lordship, by private parties
like to
taking all
hear-
the
If your
liabilities.
lordship wants to.
What is the particulars? What is the particulars? You take down hard, Mr. Dasgupta, senior counsel appearing for the writ petitioner. Writ petitioners also heard Mr. A. Kalita, Learned Standing Counsel Industries Department appearing for the respondents. First up, the basic prayer made in the writ petition pertains to claim for payment of retrenchment compensation. First up, according to Mr. Dasgupta, it is the state of Assam which will be liable to pay the amount to the petitioners, whereas Mr. Kalita submits that since the industrial unit has been transferred to
Assam Yarn Suppliers.
Assam Yarn Suppliers,
Their address is, Lordship, the registered partnership firm, Jai Hind Building,
a registered partnership firm having its registered office at
Jai Hind Building,
Jai Hind Building,
number 1,
number 1,
second floor, room number 3,
room number 3,
Bhuleswar, Bombay, 40002.
Bhuleswar, Bombay,
40002.
40003.
2.
40000.
Yeah, yes, Lordship,
How many zeros?
4 zeros.
4, then 4 zeros, then 2. They are necessary parties to this proceeding. First up, Mr. Kalita, however, informs this court on instructions that the total amount involved in the matter would be to the tune of 34 lakhs. After hearing the arguments of both the sides, this court is of the opinion that the partnership firm which has taken over the industrial unit would be a necessary party to this proceeding. As such, it is hereby ordered that so and so represented by its managing partner. The implemented respond number.
Respond number 5 he will do, sir.
Respond number 5.
5, because finance department has been implemented, respond number 4.
4 is. As respond number 5 in the connected read petition, registered to carry out necessary endorsement in the cause title. Notice be issued to the newly included respond number 5, making it returnable within 4 weeks. Petitioner to take steps by registered post with ID as well as usual process within 3 days from today. Let us thresh it out once.
No problem.
Publish.
In fact, it will help me. I will
Yes,
get the higher amount,
Yes, that's right. Let us see.
but the better will be delayed, that is it.
You sit quiet and enjoy the, let us see, let them thresh it out.
It will help me.
Yes.
May it please. This matter, your lordship, is practically heard. This is with regard to the departmental inquiry where the petitioner's punishment was enhanced from 2 years of increments to the retirement, compulsory retirement. Basically, that case your lordship has heard. I have already given a list of the dates where I have specifically given everything and the points that I have also raised. The issue that on the last occasion your lordship has raised was with regard to whether I am entitled to the back wages or not. With that regard, your lordship has asked me to produce some judgments. Only that is left, and I have I'll be giving the list of the judgments.
Mr. Manan, I
Yes.
can only give you about 7 minutes if you want to conclude it today.
I'll just give the judgments. Otherwise, since your lordship has already heard the matter, is it required for me to revise or something like that?
From my side, I have mentioned some submissions here.
How much time will you require?
15 minutes.
There are other matters. Today, we had a division bench in the morning. That is the problem. We'll have to fix it for another date and conclude it on that day.
If your lordship wants me to again go through a little bit of that, then
No, no,
obviously
some refreshing will be
yeah,
required.
refreshing, then your lordship have to, I'll take some time.
We'll have it on the 11th.
11th this month.
11th May.
May.
11.
11th of May.
Council for the petitioner is present.
Okay.
Mr. K.K. Parasul and CGC has appeared for the respondent. Registered to raise this case again on 11/5/2023 as a fixed part-head matter in the admission column. We'll finish it off and.
Yes.
Smile.
Records were called, I think.
Record available.
Right, Mr. K.K. Parasul and council is appearing for the respondents is present and submit that records have been received.
Much of this.
So I am fully prepared to argue the case, but it will take 1.5 hours to 2 hours. If
But
it
there is a judgment by the Supreme Court yesterday. Are you aware?
Yesterday's judgment, no lordship.
Mr. Das, are you aware? Are you aware? Your matter has been decided by the Supreme Court yesterday.
I have not.
You have not read. Please go through that judgment.
Yes, yes.
Bench of Honorable Justice Ram Subramaniam and Honorable Justice Pankaj Mithal. It has been held that Ayush doctors are not entitled to equal pay scale as MBBS doctors. So you will not require 1 hour now, neither side will require. Unless you can show that and Gujarat High Court judgment has been set aside.
But here the issue is not the pay scale, it is the superannuation age. In our case,
Okay.
it will help me, of course,
Hmm.
but I will have a different line of argument
So
altogether.
what really has been decided in that case, but the issue was directly MBBS versus Ayurvedic doctors, Ayush doctors.
In broader sense, yes, in broader sense, yes. But from our perspective, service condition. As an employer, up to what level we want a person,
That is.
because we have a direct judgment from this honorable court. to that effect.
No, the issue is parity.
Parity.
That is the core issue.
Core issue is parity from one perspective, but from our perspective, it is not parity. It is the total number of doctors we need in our service. Whether, because even if you give an advertisement for allopathic doctor, there is huge deficiency. Whereas in Ayurvedic, batches after batches are not being able to get employment. There is acute shortage of allopathic doctor in the government sector, and there is abundance of Ayurvedic doctors.
So it is a demand supply theory.
Demand supply theory, Lordship.
But will it be better to have a look at the
Yes,
judgment?
that's what I have also just now I have seen it.
Let me go through it. I have just now.
In any case, I will let, because Lordship, it will not be continued with this honorable court. Otherwise, I was not supposed
Yeah,
to take it.
today,
Yes, Lordship is rising at 1:15.
Lordship will be sitting in division bench.
yes,
So let it come maybe on 11th or 12th, whatever.
you are right. Here, the issue is age of superstition, but why I refer to the judgment
Yes,
is
Lord.
arguments are on the lines of parity.
Yes, because this will help me to counter the my Lord Justice H. Roy's Supreme Court judgment.
That you do whatever you want. But we'll fix it then when?
11th, as my learned friend suggests.
Again, it will be crowding 11.
Otherwise, there is no urgency from our side, Lordship.
But we have urgency.
These clients are retiring.
Yes, that's
No, but we'll do it. Let us finish it on 18th. These are fixed parted matters. 18th, are you there?
till now, yes.
Or we can all shift somewhere else. Mr. Saika's availability is a problem.
18 till now, there is no such. If it is, I will inform 2 days earlier.
Mr. B.C. Das Ganesh, senior counsel appearing for the writ petition, has also heard Mr. Saika Learned, Advocate General Assam, appearing for this state. It has been brought to the notice of this court that only yesterday, the Honorable Supreme Court of India has delivered a judgment on the point of claim of parity of Ayush doctors. with
Parity
the
of scale.
Parity of scale
Base.
and service conditions of Ayush doctors in comparison to vis-a-vis the MBBS doctors. Full stop. Although the issue involved in this batch of writ petition pertains to age of superannuation, yet since the basic argument is on principle of parity, it has been agreed at the bar that examination of the aforesaid judgment would be essential. As such, hearing of these matters stand deferred till 18th of May 2023. List these cases in the admission column as first items on 18/5/2023.
Highly obliged.
18/5 we'll finish it.
Lordship.
That matter. Perhaps your lordship is having time constraint today.
Yes, yes.
So can I pray the matter may be taken up on 9th, my lord? It is a part-heard matter and
9th, my availability in Guwahati is doubtful.
oh, my lord is not available in Guwahati. Can it be on 16th is a Tuesday?
16th.
16th. On that day, we will conclude and we'll give I've prepared the notes on arguments, but I have to check the typographical corrections.
This will go on. 16 there is another DB, but after that we can try this. You will never have a date with everything open.
16 will try.
Due to time constraints, hearing of this matter would not be possible today. As such, on the request of learned counsel for both the sides, registered to list this case again on 16/5/2023 as a fixed item.
Highly obliged.
Lordship, I have received instruction that Lordship,